J'ouvre maintenant la réunion.
I call this meeting to order. Welcome to meeting number 120 of the House of Commons Standing Committee on Canadian Heritage. I would like to acknowledge that this meeting is taking place on the unceded traditional territory of the Algonquin and Anishinaabe people.
Pursuant to the order of reference of Wednesday, November the 22nd, 2023, the committee is resuming its consideration of Bill C-316, an act to amend the Canadian Heritage Act Court Challenges Program. Before we begin, I want you to know that we have a hard stop at 6:30. I've asked the clerk to see if we can get resources to go after that, because we have been late starting, because normally 10 minutes after a vote, we are supposed to be ready to roll. So before we begin, I want to ask all members to consult the cards on the table for your guidelines for using your headsets, etc., and to make sure that you know that you can put your earpiece down on the little round disc on your table if you're not using it. Remember to keep your earpiece away from all microphones at all times. And you can no longer use the gray headpieces. You only have to use the black ones. When you're not using your earpiece, place it face down on the sticker placed on the table for this purpose. Thank you for your cooperation. Today's meeting is taking place in a hybrid format. And I want to make a few comments for the benefit of members and witnesses. Please wait until I recognize you by name before speaking. For members in the room, again, raise your hand if you wish to speak. For members virtually, use your virtual hand. And the clerk and I will manage your speaking order as best we can based on when we saw your hand up. And we appreciate your understanding. Now, remember, all comments should be made through the chair. Now, Bill C-16, an act to amend the Canadian Heritage Act. I would now like to welcome our witnesses from the Department of Canadian Heritage who are available to answer questions during the clause-by-clause consideration of the bill. And the members from the Department of Canadian Heritage are Blair McMurran, Director General, Strategic Policy and International Affairs, Flavie Major, Director, International Affairs and Human Rights, Strategic Policy and International Affairs. Today, we are dealing with the bill clause by clause, and so now I shall begin. Now, I hope you have your clause by clauses in front of you. Now, pursuant to Standing Order 75-1, consideration of Clause 1, which is a short title, and of the preamble are postponed to the end of the clause by clause. The chair, so I'm beginning by calling Clause 2. Yes? Did you have your hand up, Mr. Nur Mohammed? Yes.
Yes, so obviously we would support Clause 2.
Well, we're looking at, first and foremost, supporting the whole of Clause 2. G1 is the one we're looking at first.
Well, there is a change we're proposing.
Yes, go ahead.
So the change in Clause 2 be amended by replacing lines 10 to 16 on page 2 with the following: that 1A, we establish and implement the program referred to in Section 7.1 of this Act, paragraph 43(1)(c) of the Official Languages Act, that is administered by an organization independent of the Government of Canada. And so the effect would basically be to clarify that the program contemplated in Clause 2 of Bill C-316 is the same program as the one contemplated in 7.1 of the Department of Canadian Heritage Act and in paragraph 43(1)(c) of the Modernized Official Languages Act.
Okay. Yeah. Now, so you are amending G1? Yes. All right. So any discussion? Yes? Mr. Lawrence.
Thank you, Madam Chair.
And then Ms. Thomas.
Just was wondering if the officials should just give us a quick briefing on the effect of Mr. Nur Mohammed's proposal.
Okay. Merci, Madame la Présidente.
Yes, go ahead.
Oui, certainement. I'm very happy to explain the intended effect of this amendment, which is to clarify essentially that three references to this program in Canadian law are referring to the same program. Two new provisions were created with the modernization of the Official Languages Act, Bill C-13, in Section 7.1 of the Department of Canadian Heritage Act, and as mentioned, in a provision of the Modernized Official Languages Act. So we're simply seeking to have a maximum of clarity that we're talking about the same program by using the same language in Bill C-316 to describe that program.
So you're just changing the language to reflect the modernization of the Languages
That's right,
Act?
to align it exactly word for word.
Now, any more discussion? Mr. Surrey? And, oh, sorry, Miss Thomas was before Mr. Surrey. Ms. Thomas?
Thank you. So sorry. So I just want to make sure that I understand. Mr. Nur Mohammed made a slight change to G1. Is that correct? Do you mind just, sorry, through you, Chair, do you mind just making, can you just clarify that for me? And then I do have a question to the officials.
Sure. So I'll read what the amended version would look like, if that helps.
Sure.
So basically, it would say the result would be establish and implement the program referred to in Section 7.1 of this Act and paragraph 43(1)(c) of the Official Languages Act that is administered by an organization independent of the Government of Canada and.
Sorry, am I missing? Isn't that what you have here?
So that's,
okay, so
that's the result.
you're not amending G1.
So, well, no. So it's for consistency alignment. Yeah.
Okay. Okay.
It is the amendment. Yeah.
Sorry, I'm so sorry. I thought you were saying that you were changing it a bit.
That is the amendment. So
okay,
that's
I apologize.
Yes.
My misunderstanding. Perfect.
Members could speak a little slowly when they're reading out something for us, because some of us are not particularly bright and cannot write as quickly, i.e. me. So there you go. Just slow down, guys. Okay, go ahead. Mr. Surrey.
Oh, sorry. No,
Sorry. Oh, that was just the first one. Okay.
Yes, sorry. Thank you for that clarification, Mr. Nur Mohammed. My question to the officials then is this. I just want to make sure, just to piggyback on Mr. Lawrence's question, I just want to make sure the language here then, really the reason for that is just to bring it into alignment with Bill C-13.
That's correct. We just want to avoid potential legal incoherence between the laws, the two laws involved.
Understood. Okay, thank you.
Surrey.
Thanks, Madam Chair. Yes, and what was proposed here to add and to make it align with C-13, and what I'd like to do at the end of the what Mr. Mohammed just presented is submit a sub-amendment, and I would ask the clerk to circulate it to all the committee members. And while you're doing that, I'll just read it, if that's okay, Madam Chair? Slowly, okay. So obviously what was said just now at the end when you say the Government of Canada and then we do add whose purpose is to provide funding for test cases of national significance to be brought before the courts to clarify and assert constitutional and quasi-constitutional official language rights and constitutional human rights that are guaranteed by the Canadian Charter of Rights and Freedom. So that would be the language, and my understanding is all members will receive the sub-amendment. And essentially here, the reason for this addition, the sub-amendment, is really looking at the court challenges program. Obviously we all know that it helps empower the most, vulnerable Canadians to fight for their rights under the Charter in that way that it helps to make, the Charter stronger and to connect it with the needs and challenges of people that most need of its protection. So the sub-amendment, really emphasizes the importance of the Charter and is a timely sub-amendment given that the recent promises that we have here by the leader of the Conservative Party to take away some of the charter rights of groups with a notwithstanding clause. So that's really important that we emphasize this. So I just want to make sure that this clause isn't part
Thank
here.
you, Mr. Surrey, but I think Mr. Nur Mohammed has, is it an amendment actually, Talib? I still have difficulty understanding if it's an amendment or not.
Yes.
Correct.
It's
It
an
is
amendment.
It is an amendment.
It is
correct.
an amendment. Okay. All right. So before we go to the amendment, let's deal with Mr. Surrey's sub-amendment.
Could we
Yes,
just
Ms.
suspend?
Thomas.
Sorry. I was going to say, could we just suspend this is substantive?
Suspend while everyone talks amongst themselves. Thank you. The sub-amendment we have, Mr. Lawrence.
And either Mr. Seri or the officials, I'm happy whoever can respond to the question. I'm just trying. This is a what appears to be a substantive amendment, and I'll be candid. I don't fully understand the impact of it. Maybe I could just start with the officials there, and they could provide us. They'd be kind enough. The impact of this sub amendment, as it were. So.
Yes, thanks, Madam Chair. It appears to us that this would This amendment would add descriptive language around the program that is very consistent with the references elsewhere in the Department of Canadian Heritage Act and the Official Languages Act, like to actually use almost identical language in describing the program.
Okay, and I'm legitimately just sincerely trying to understand. So, so was it? You don't need to assess blame. I don't want you to do that. But was it an omission to not have this in the initial language? This is to clarify, or this is to validate, or what the purpose? Because my understanding is that that this legislation is to allow for court challenges. In other words, for individuals to bring claims that they're funded by the federal government against missteps by the federal government, and so in the absence of the sub-amendment to provide funding for test case, I thought that was the whole purpose of it, but we didn't have it in before. Is it somewhere else in there? I'm just sincerely and legitimately just trying to understand why this was not in there before and why it's in now. So.
Okay, thank you, Madam Chair. The original amendment, I think, was a little more factual, like it referred to the relevant articles of the Department of Canadian Heritage Act and the Official Languages Act without getting into the description. The sub-amendment appears to bring some of that descriptive language into it, but very closely aligned, like the language around test cases of national significance is identical to what appears in those other articles.
I appreciate everyone's patience here, but so the amendment brings this program to the Official Languages Act, if I've got that correct, or am I off there? The original, not the sub-amendment, the amendment, right?
That's right, Madam Chair. The original amendment is it's establishing the connection between this clause of Bill C-316 and a clause in the Official Languages Act that refers to the same program, the Court Challenges Program. It's also trying to establish a connection to a reference to the Court Challenges Program in the same act, in a different section of the Department of Canadian Heritage Act.
Okay, so and underneath the Official Languages Act, there is a Court Challenges Program, correct?
That's right. There is now a reference further to Bill C-13.
Right, and so. I'm sorry. I apologize. I'm not normally this obtuse, but so we've got the Official Languages, which has a Court Challenges Program in it, right? And then we have this amendment to sort of recognize that in this private members bill, or am I off there?
Thank you, Madam Chair. As I understand it, I think it's wanting to simply use the same language in Bill C-316, like to describe what the program is meant to do.
Oh, okay. So we're amending the Official Languages Act to reflect the language in 316. That's the original amendment, right? I got that wrong.
I think, Madam Chair, amending Bill C-316 to reflect what is in C-13.
Thank you. And so we do that in the amendment, and then we add the sub-amendment to make that language match better, for the lack of a better term, with what's in the private members bill. Is that right? Is that what we're doing? Or no? Sorry.
Madam Chair, the sub-amendment is seeking to bring language into Bill C-316 from the Official Languages Act, and as it happens elsewhere in the same bill, the Department of Canadian Heritage Act. I don't know if it would be helpful to read out those provisions, those two other
Very
provisions.
helpful, yeah.
I could do that. The allusion is to Section 7.1 of the Department of Canadian Heritage Act, which was added by C-13. So this provision states, to promote a greater understanding of human rights, fundamental freedoms, and related values, the Minister of Canadian Heritage may take measures to provide funding to an organization independent of the Government of Canada, responsible for administering a program whose purpose is to provide funding for test cases of national significance to be brought before the courts to clarify and assert constitutional human rights. So this is a provision referring to the human rights stream of the Court Challenges program. There are two streams. There's a human rights stream and an official languages stream, Madam Chair. So I could read the provision from the Official Languages Act now, if that would be helpful.
Please, yeah, thank you.
Which corresponds. This is paragraph 43, section 1. The Minister of Canadian Heritage shall advance the equality of status and use of English and French in Canadian society, and to that end may take measures to, and this is subsection C, provide funding to an organization independent of the Government of Canada responsible for administering a program whose purpose is to provide funding for test cases of national significance to be brought before the courts to clarify and assert constitutional and quasi-constitutional official language rights.
Okay, and sorry, and then I apologize to the interpreter for pulling away from the microphone. Okay, so without the amendment, Mr. Surie's private member's bill would not have sufficient clarity that the Official Languages Act reviews or court challenges are meant to be administered by this organization independent of the Government of Canada. Is that, have I got that right or no?
Madam Chair, as I understand it, the amendment would seek to add extra, even more clarity by using the identical language from the provisions it's referring to. Like the original amendment simply referred to section 7.1 and paragraph 43(1)(c). This would go further and spell out in identical language the program we're talking
So okay, now it's coming a little bit clearer to me. So in the original PMB, it just said 7.1. In this amendment, we have included the language afterwards, and then we've sub-amended it just in case there was any doubt as to sort of the purpose behind the Court Challenges Act, which is probably would not have gotten challenged, but it's just there to add extra clarity. Is that, have I got that right?
I believe so, Madam Chair, yes.
Thank you, Mr. Lawrence. I go to Ms. Thomas.
Thank you very much. I believe you've clarified most of what I needed to have clarified, but I just, for absolute certainty, I'm just wanting to make sure it is then a little bit redundant or repetitive because it is already being covered off in those previous two acts that have been mentioned, and then it's taking that language and just using it in this bill again. So I'm just wanting to make sure, like, being repetitive, you're saying it brings clarity, but is there any chance of that actually muddying the waters instead of bringing clarity?
Madam Chair, I would venture to say not. I would agree with the statement that it brings extra clarity by using the identical language. It's kind of been amalgamated from the two other articles into one, but I believe it would add clarity.
Thank you, Ms. Thomas. Mr. Shampoo.
That's fine.
Merci, Madame la Présidente.
Thank you, Madam Chair. I have a question. I don't want to debate on the amendment, which doesn't seem to cause any harm here, but I have a question for Mr. Miller regarding the adoption of this amendment. If we adopt G1, would it have an impact on CPCs 1, 2, and 3? Would that mean that CPC 1, 2, and 3 could not be tabled?
Thank you, Madam Chair. Oui, en effet, Monsieur Champoux, vous avez raison.
Indeed, Mr. Champoux, you are correct. If G1 is adopted, whether or not it is amended, CPCs 1, 2, and 3, NDP 1, CPC 4, 5 could not be tabled.
Merci, Madame la
Thank you, Madam Chair. I don't have any additional questions.
So I think I will call the vote on the sub-amendment. Ms. Thomas and Mr. Lawrence.
Sorry. I just wanted to, in the preamble to Mr. Suri's.
Lawrence, Ms. Thomas's hand was
Oh, sorry.
up before yours.
Sorry, I thought you were going for the calling a vote. Sorry, my apologies.
No,
Yeah. I in Mr. Suri's preamble, he referenced charter protection. So, for example, when the Liberal government illegally invoked the Emergency Measures Act in violation of charter rights, is there anything in this sub-amendment that would provide additional protection to those Canadians who had their bank accounts frozen, their rights violated as found by the court?
Thank you, Ms. Thomas. Do you require a response to that? Thank you. Will the members from Heritage please respond? Thank you. Officials?
Thank you, Madam Chair. I think we would observe that the reference to the charter in the proposed sub-amendment seems fairly neutral and factual, given the fact that the program is oriented around supporting court challenges involving certain sections of the charter. We would see it as consistent with the parameters of the program.
So it clarifies, but it doesn't provide any additional protection to charter rights for Canadians. And of course, given the fact that this will allow for more court challenges, which could then have people bring challenges. But the actual sub-amendment does not strengthen the charter really in any way.
Thank you, Madam Chair. I would see it as a fairly factual reference to the program as it is now.
Ms. Thomas?
Sure. I guess I would seek clarification. Understanding then that there would be other amendments that would potentially be lost if G1 was to be passed. Would there be an opportunity then to propose amendments, I guess, from the floor? So assuming that G1 is accepted.
If G1 passes or is adopted, amended or not, CPC 1, CPC 2, CPC 3, NDP 1, CPC 4 and 5 cannot be moved due to a line conflict, as Mr. Miller said earlier on.
I understand that. My question was, could other amendments be put forward from the floor then?
To G1, which is what we're dealing with at the moment.
Those would be sub-amendments. I'm asking
Yes,
if
it would be,
amendments could be put
of
forward
course.
to
Yes.
Clause 2.
You can move sub-amendments to G1 if you wish. Pardon. Sorry, Philippe.
Yes. I'm just.
You mean sub-amendments further to G1? No.
No, Chair, I
Okay.
don't. I mean, if G1 were to pass with the sub-amendment or without the sub-amendment, would we be given opportunity to move an additional amendment from the floor with regards to Clause 2 with G1 as a part of it?
Thank you, Madam Chair. To Clause 2, not the lines that would be amended by G1, so the lines 10 to 16 of the bill would be closed for amendments. If you wanted to add amendments after line 16, that would be an option in Clause 2. Yeah.
Thank you.
Mr. Waugh.
I think what Ms. Thomas was getting to, if G1 does pass, is we're looking ahead to CPC 1, 2, 3, 4, and 5. If there was maybe, and I'm not putting words into Ms. Thomas, but maybe there was something that we wanted out of there is now the time to amend that from CPC 1, 2, 3, 4, 5, if there was a line that we kind of wanted. Now that if a G1 does pass, and then, you know, the rest has been thrown out here.
Mohammed?
So I'm just asking for clarification for CPC 1 to 5.
Thank you, Madam Chair. Once G1 has been sub-amended, let's say the sub-amendment is adopted or not. Actually, it doesn't matter if it's adopted or not. You can always propose another sub-amendment to G1. And then that would be maybe an option you can consider.
Okay.
Thank you. Ms. Martin?
Madame la Présidente, merci pour la clarification.
Thank you for this clarification. I would like to know, for the amendments that we're going to examine, it would be good if you could tell us from the start of the discussion. We need to know what the impact is going to be of adopting an amendment on the future amendments. That would be very useful. Thank you.
Well, I think that the heritage official said that it's a clarification amendment, etc. But I think we have to vote on the sub-amendment. I don't understand your question, Martin.
J'ai juste demandé, Madame la Présidente.
I just asked, Madam Chair, that we be told at the start of our discussions, so told whether or not an amendment would have an impact on future amendments. That's all.
Well, I think future amendments to what? G1? Because we're dealing with G1 right now. I don't know if you're mentioning future amendments to G1 or what.
Je vais répéter doucement.
I'll repeat myself. I just want to make sure that you can hear me. When we start looking at a new amendment, whether it be G1 or any other amendment, at the very start of the discussions, if you could tell us whether or not adopting an amendment will have an impact on other amendments. That wasn't done at the start of our discussions on G1, and I would like for us to do it for the other amendments.
All right, if the amendment is moved, I will reread the note after it's moved. Is that what you want to know, Mata? I'm still not understanding what you're asking.
No, it's not okay. It's not okay. This is very important.
Is explaining what you want, Martin, because I'm still not pretty clear. But if we move a new clause or a new motion, we're going to have to. I'll read out for you what its impact will be on the other ones at the very beginning. Is that what you want?
Oui.
Okay. Thanks. Okay. Good. Mr. Lawrence.
Thank you. Just furthering what my colleague said, which I think is an excellent suggestion, is I have been in past clause by clauses. Mr. Miller always doing fantastic work there. We spent many hours together. In other committees, I think this is optional. Mr. Miller could maybe comment on whether this is, but in other committees where we've had amendments that would in fact knock out ladder amendments, so exactly what we were talking about here, we've actually had the opportunity, or we've been, members have given us the indulgence of talking about all the options on the table. Because while you may want to, you might like one, you think it's great, it's clarifying it, but you see 3 or 4 is actually a better one. And so before we sort of discuss them as a group, and then we sort of work collaboratively either to pick one of the horses that are in the race, or amend one of them, or even consolidate them, as often they're very similar. So.
Thank you, Mr. Lawrence. Now I'm going to go to the sub-amendment, and I'm going to call the vote on the sub-amendment. Please, Clerk. Is there any Anybody who is opposing the sub-amendment? Seeing no opposition, then do you want me to call a vote, or shall I just go ahead and say that the sub-amendment is carried? Now we've got to go to the amended amendment that Mr. Nur Mohammed moved. Yes, Ms. Thomas? Oh, sorry. I don't. Every time, this is what happens when I'm speaking and the speaking bar is on. On his sub-amendment, that's what we're voting on.
Mr. Nur
No.
Mohammed's,
After,
yours.
I did not see any opposition
That's right.
to
No,
the
that's fine.
sub-amendment, so it's passed. Now we're dealing with Mr. Nur Mohammed's amended amendment. Yes, Mr. Nur Mohammed.
Ms. Ashton.
Nikki, sorry, Nikki.
No, it's fine. I wanted to propose a sub-amendment to G1, if it's still possible, although...
It is possible to have a sub-amendment, yes.
Okay, so if I can propose the following amendment, sub-amendment. A, by...
Excuse me, Nikki, excuse me.
Yeah.
I believe I was next on the speaking list, and I believe you called on me and then got distracted.
I thought you were no longer going to speak, that Mr. Waugh was speaking. I'm so sorry, Ms. Thomas. Will you go ahead and speak? Thank you. Go ahead and speak.
Okay, thank you. I would like to offer a sub-amendment to Amendment G1. So I do apologize. I am having to act on the spot here, so I am trying to figure out exactly how to fit it in best. Okay, so after independent of the Government of Canada, so at the end of G1, I would insert the following, and that the program be overseen by a board of directors composed of members appointed following consultations with each of the political parties represented in the House of Commons, and then it would continue on with the sub-amended text.
Could you please read that again, Ms. Thomas? By an organization independent of the Government of Canada.
So at the end of G1,
Yes?
I would insert,
The amended G1. From the sub-amendment of Mr. Saray.
at the end of G1,
Yes?
I would insert, and that the program be overseen by a board of directors composed of members appointed following consultations with each of the political parties represented in the House of Commons, comma, and then it would continue with the sub-amendment that has been added to the text.
Right? Thank you.
If I may, just the significance of this is just, it just makes it a nonpartisan entity. So it allows there to be accountability for whoever is in government at the time, rather than allowing for the appointment to be just made by that government. It would allow for each political party to be consulted, to have input, and then for ultimately, of course, the final decision has to come from the minister. But it at least allows for that consultation, which allows for cross-party bridges to be built, would be the hope. This comes out of witness testimony that we heard from numerous witnesses talking about the fact that the Court Challenges program can be used for good. However, it can also become partisan in nature because, of course, it is whoever happens to be the government at the time that can flex in terms of that decision-making process. And so we've observed over the years Liberals, Conservatives, and how they've managed it. This sub-amendment would allow for all parties to be a part of the decision-making process in terms of that board of directors. Therefore, hopefully achieving a more nonpartisan approach.
Thank you, Ms. Thomas. Is seeking to amend the Department of Canadian Heritage Act to maintain the Court Challenges program and appoint the members of the board overseeing the program would result in payments out of the public treasury and would require a royal recommendation. And that's because of House of Commons Procedure and Practice, 3rd edition, states on page 772, since an amendment may not infringe upon the financial initiative of the Crown, it is inadmissible if it imposes a charge on the public treasury or if it extends the objects or purposes or relaxes the conditions and qualifications specified in the royal recommendation. So I'm ruling that amendment inadmissible.
If I may.
Yes, go ahead.
There is already an entity that is put in charge of there's already an entity that is put in charge of the Court Challenges program, and within that entity there's a board of directors. So I'm not asking to appoint a new board of directors. I'm not asking to spend extra money. I'm asking within the framework of the program, there is already an arm's length entity that is put in charge. I'm asking that the parties would have input as to who is at that table.
I hear your explanation. I'm going to ask Mr. Mellor to tell me what he thinks of that suggestion. Thank you. So you may have to challenge the chair.
Okay. I'm not sure how this works. If we go to legal and we're asking for an amendment to be drafted, then perhaps legal could bring that to our attention so that we would have an opportunity to draft something that could be admissible. I was set up for failure then, if that's the case.
Mr. Mellor, would you answer, please?
Can I have a
She's
second?
asking,
Yeah,
yes.
yeah, can I have a second? Thank you, Madam Chair. For all members, once you submit amendments or prior submitting amendments, you can always consult us before submitting them officially, and we would get back to you in terms of if there is a royal rec issue or if there are scope or principle of the bill issue, and then we can work to fix the problem if the problem is fixable. In this case, because the members of the boards are appointed, it means that anybody could be paid out of the CRF. Once you appoint somebody, the Interpretation Act provides for the payment of these people. Could be the ones you're mentioning or other people.
I think the process of this committee is insane. Thank you. It's just very troubling. I have been a part of this process at other committees, and generally there are two things that happen that are not happening here. One, we are given a heads up if something is determined inadmissible so that we have the opportunity to suggest something different. So to surprise me at the table today is unfair. I worked with legal to accomplish an end. This was the way that they recommended I achieve that end. So taking their expert advice, I've come to the table in good faith that I would be able to accomplish the end. I never wanted to spend money. That was not a part of what I asked to do. So that's a letdown. As a legislator, I have been let down by the system. So I'd like to know how that can be remedied, because that is very serious. That's actually a violation of my parliamentary privilege to be able to come to this table with confidence and be able to move exactly what I intended to move. And secondly, the other process that is not going the way that it needs to today is when the amendment is read out, to my colleague's point, we do need to know what effect it will have on other amendments that are coming after. And to withhold that information from us again is a violation of our parliamentary privilege.
Ms. Thomas, I would like to suggest that I couldn't rule on your amendment until you actually made it. I ruled on you telling it was inadmissible because of The decisions I told you were in sections of page 772 of the Procedure and Practice of the House of Commons. That's all I can do. I cannot presume to know what's going to happen. If you spoke to legal and you say legal said this was okay to do, then I guess we're going to have to find out what that happened, because I am just reading you that this is inadmissible because of the reasons that I gave you. I am following the rules. I cannot make these decisions. I am not legal and I'm not a lawyer. I'm running this committee the way it should be run according to procedure. Thank you. And I read out the procedure as soon as you finished reading out your sub-amendment. So I couldn't do it before you read your sub-amendment because I didn't know what you were going to say.
Madam Chair, through you, my ask is to the legislative clerk that we be given a heads up if something is deemed inadmissible.
Mr. Mella?
Thank you, Madam Chair. This is an opportunity for all members to have when they submit the amendments to either to the clerk before the committee starts, before anything starts really, or the members can consult us prior to submitting them to the clerk of the committee, and we can have the discussion at that point to see if they are procedural admissible or not. But it's not something we do proactively because we assume that the members, generally speaking, don't want to know what the answer is.
But we not want to know. We would want to be stupid. We would want to come to the table unable to.
Ms. Thomas, did you consult the legislative clerk before you brought in this amendment?
Madam Chair, I created all of my amendments with the assistance that was provided to me based on an email that was sent from the clerk outlining the resources that I had at my disposal. I used those resources. If there were further resources that were available to me, that was not made known. In no way was an email or any other form of communication sent to me or to my office recommending that we double check the work that was done by legal by running it by the legislative clerk and his office.
It's traditional, I think, during clause by clause for people to consult with a legislative clerk. So, thank you. But go ahead, Mr. Mella, if you wanted.
Yes, thank you, Madam Chair. A memo is sent to all members prior to submitting the amendments, indicating what the deadline for the amendments are, what the dates for the amendments to be submitted are, and when the clause by clause will be taking place. On that memo, there are two information that are important to members to know. Who is the legislative counsel, so basically the lawyer who is going to draft the amendment according to the law, and who the legislative clerk is in order to help members to understand what the procedure are, and if they have questions regarding procedure, they can consult us. That's on the memo that's sent to all members every single time there is a bill in committee.
So if I followed that email and I sent my desire to the email address that was provided to me, and they sent back the recommended amendment in this final form that I have in front of me today, you're saying that in addition to that counsel that was provided to me, I also needed to then double check with with you.
Thank you, Madam Chair. Yes, indeed. In 2001, there was a speaker's ruling. I don't want to go back to what was once the legislative clerks and the office of the law clerk were once under the same umbrella. In 2001, that was divided in two separate entities. So nowadays, as the memo provides, there is one entity that is the lawyer's office, the office of the law clerk, that has a specific relationship with the members, which is client privileged from the get-go, and nothing is shared with us. That's why the memo has second part, which is if members need procedural advice on the admissibility of the amendments, they should contact us once the amendment is provided by the law clerk's office, and then at that point we can provide them with the procedural admissibility advice that we can have at that point.
And so from the point that amendments were submitted to this committee, The legislative clerk was aware of what would be admissible and what would not be admissible, but that information was withheld from us until we came today.
Sorry.
Yes, Mr. Surrey.
Madam Chair, the rules and the debate here that's happening between Mrs. Thomas and the legislative clerk, these are the same rules that have been in place for decades. You've already, this is the clarification that Mrs. Thompson is asking. Maybe you should ask your team, because this
Madam
is the
Chair,
same rules.
This is not a valid point of order.
Yes, the chair has already ruled.
I will allow the point of order. Please. Thank you. Go
So,
ahead, Mr. Surrey.
Madam Chair, just quickly, you've already ruled, and now there's a debate going on with the legislative clerk, which is not accurate, because these are the same rules that have applied for every other committee, for every other sub-clauses, clause by clause, that I've been part of, and they've been in place for decades. So I don't understand what's happening here right now, Madam Chair. But you've already ruled, and if a member wants to challenge your ruling, there should be not a debate, there should be a vote on that ruling.
With you, Mr. Surrey, and I asked the member if she was challenging my ruling, and she did not respond. Are you challenging my ruling, Ms. Thomas?
I was simply seeking clarification.
Sorry, I didn't hear that.
I was simply seeking clarification.
And I think Mr. Mellor gave you clarification. Thank you. So we will
Madame la
now
Présidente.
move to Ms. Ashton, who
Madame la Présidente,
had
okay.
her hand
Madam,
there to Ms. Thomas,
Right.
but now
Madam Chair,
to Ms. Ashton.
Madame
Ms.
la
Ashton,
Présidente.
go ahead.
Madam Chair, I have a point of order.
I apologize.
Moi-même,
I don't want to draw out this debate, but I think we have a good opportunity for improvement here. Mr. Miller gave a good explanation, and I agree with Mr. Seri that these rules are in place in committees, and it's not the first time that we've seen an amendment that is deemed inadmissible. But it would be good to know, for example, with CPC2, will it receive the same decision? And same for all the amendments, and amendments that will be impacted by our vote on G1. I think it would be important to know if CPC2 is admissible, if CPC3 is admissible, because the vote on our vote on G1 is going to have an impact on that. And so if CPC2 is also inadmissible, it would have an impact on our vote on G1. So perhaps we could see what the future amendments are going to be and see what's admissible or not.
If G1 is adopted, CPC1, and that means adopted, amended or not, CPC2, CPC3, NDP1, CPC4, and CPC5 cannot be moved due to a line of conflict.
est-ce qu'ils sont recevables?
But are they admissible?
Sont-ils recevables?
Are they admissible?
One which is on the table right now.
Oui, mais le vote sur G1 va faire que...
Yes, but the vote on G1 will have an impact on CPC2. You just said that CPC1 is inadmissible. I would like to know if CPC2 is inadmissible, because it will have an impact on my vote on G1. If CPC2 is inadmissible, then my thinking will be different. And so I want to know if the amendments that are impacted by G1 are all inadmissible.
To answer that,
Thank you, Madam Chair. Monsieur Champoux, si G1 est
If G1 is adopted, whether or not it is amended, lines 10 to 16 can no longer be amended. So CPC 2 and 3 pertain to those lines, but before voting on G1, you could propose a sub-amendment that would modify G1. Now, regarding your question on the admissibility of CPC 2 and 3, we can only judge that once it has been moved. Thank you for responding to my question.
Point of règlement.
point of order, Mr. Thomas, Mr. Lawrence.
Mr. Miller.
Because I have Ms.
You have before,
Ashton with a sub-amendment
but this is a
patiently
point of
waiting.
order, so that trumps
Go
that. That's
ahead,
the way
it's a
this
point
works.
of order. Please state your point of order.
So the point of order, Mr. Miller, you have to me before provided whether something is admissible or not. That's completely allowable. You can right now tell us, in fact, it's your obligation to tell us whether 2 or 3 are admissible.
I don't know how else to say it. It will depend on whether G1 is passed or not. Now, everyone knows that, so it's going to be up to anyone to vote against or for G1, or if they want a sub-amendment, to move it now, because we're still dealing on the table on a point of order, is still G1. So, thank you.
We are just asking, Madam Chair, point of order, shouldn't be that difficult. We're asking for whether 2 or 3 are admissible or not, and whether G1 passes or not is incidental. Are G2 and 3 admissible? Sorry, CPC. My apologies. 2 and 3 admissible. This is a simple question.
Well, and I will ask Mr. Lawrence, if G1, which is according to the orders of this meeting, G1 is on the table. Right. Now, we have to vote on G1. If it passes, I've read again, CPC 1, CPC 2, CPC 3, NDP 1 are not going to be admissible because of the line. So we need to get G1 dealt with. If you want to amend G1, as Mr. Miller said, please do.
Point of order, and we're just at cross purposes. I think this is a misunderstanding, Madam Chair. So it's not me. In order to decide whether we want to vote on G1, we need to know whether CPC 2, 3 are admissible. That informs our vote. If we were before the meeting, I could call Mr. Miller, correct me if I'm wrong, and say, hey, what's your feelings on CPC 2 and 3? Do you believe that's admissible? Ultimately, it's your decision, Madam Chair, but he would inform that decision. And so I'm just asking CPC 2, CPC 3, if G1 fails for whatever reason, would they be admissible?
Point of order.
Try to answer the question.
Point of order.
Yes, sorry, Mr. McKinnon.
Thanks. I just wanted to clarify for Mr. Lawrence that you can't rule anything inadmissible until it's been moved. The distinction between these other amendments and this one is whether they can be moved at all, and that's due to a line conflict. So it cannot be answered whether they're inadmissible or not, but we know for a fact that if G1 passes, there will be a line conflict with these other matters. So they cannot be moved, not because they're inadmissible, but because there's a line conflict.
Indulgence to respond just because Mr. McKinnon has cited me. So, Mr. McKinnon, I understand what you're saying, that we will not be able to move 2 or 3 if 1 passes. But you're allowed to go to the legislative clerk, as Mr. Miller just said, and even if it's laddered down on the slate, and it may be ineligible, he can't make a ruling, but he can let me know, in his opinion, whether it would be admissible or inadmissible.
Mr. Miller, please answer the question.
Thank
you.
Thank you, Madam Chair. Indeed, if you were to call me, if any member were to call me, no, sorry, let me rephrase that, not any member, talking about Mr. Lawrence and his amendment, not Mr. Lawrence's amendment to all members, but Mr. Lawrence's amendments. If you were to call me and ask me, what do you think of my amendments? I would give you the procedural advice I would give any member on their own amendments, and then yours. I would say it's possible, inadmissible, or admissible, but I always add, at the end of the day, it's the prerogative of the chair to rule on the admissibility of any amendment. And of course, that can only happen when they're moved. So we are in a bit of a situation here where you want to know something.
But you can provide it now. You can provide your advice. Like, it's ultimately the chair's call whether she deems it inadvisable. But in your opinion, Mr. Miller, are CPC 2 and 3 admissible?
Well,
So which comes first, chicken or the egg? Yeah.
Now.
I mean, they are.
Sorry, Mr. Nur Mohammed?
No, I was, Madam Chair, I was just going to say, I think that the question that Ms. Thomas has asked is a reasonable question. It would seem to me, and, I by no means claim any expertise or intelligence, but it would seem to me, notwithstanding what the vote is, the admissibility of those two clauses, I mean, they would be admissible and would or would not work on the basis of a vote on them in their own right. So I think we spent a lot of time trying to answer whether or not, notwithstanding what the result of the vote is, that these things that they have put forward are in fact admissible. And I have no issue with them in terms of like putting them to a vote as we ordinarily. Does that answer the question you're trying to get to?
I'm gonna talk to you on the way out, Mr. Miller.
These things are admissible, but until we get them on the floor to be voted on, we cannot deal with them. And so we cannot do that until we dispense with or dispose of G1 in one way or the other. And I also have a sub-amendment to G1 on the floor by Ms. Ashton. So I would like to go to that, please. Ms. Ashton, your sub-amendment.
Okay, thank you very much. And I should say I'm basing it off of the second part of NDP 1. We were under the impression that we could still make the sub amendment in our deliberations. However, anyway, the piece that I would like to put forward is by replacing line 16 on page 2 with the following quote, rights, comma, particularly such rights that are recognized and guaranteed by the Canadian Charter of Rights and Freedoms and the Canadian Human Rights Act, comma, and. End of quote. And so essentially the addition here is the reference to the Canadian Human Rights Act, which we believe is important grounds for charter challenges, or rather court challenges, I should say. And we know that to be the case from the recent historic court challenge put forward by Cindy Blackstock based on First Nations rights grounded in the Human Rights Act, and so beyond the Charter of Rights and Freedoms. And so we are looking to include the Human Rights Act as part of this important legislation to ensure that people that are fighting for their rights, like First Nations, are able to do so on the grounds of the Human Rights Act.
Ashton, we are still dealing with G1. So is this a sub-amendment that you're placing to the current G1 now? Or are you okay. So you're bringing a sub-amendment to G1. Where exactly would you like to see that go?
It's the line 16 on page 2. And essentially it is adding the Human Rights Act after the reference to the Canadian Charter of Rights and Freedoms. I believe we sent a copy.
Thank you, Nikki.
Yeah.
Thank you, Madam Chair. What you're trying to do is propose a new amendment because you're amending lines of the bill where you should be amending the text of G1. So in order to do that, it would be a sub-amendment where you would tell the committee where exactly your text is going, what is the text you want to add to G1, and where it is going.
Okay, so the comment about line 16 on page 2 is not enough information in that respect. I understand what you're saying about G1, but I did indicate the line.
Go ahead, yes.
No, thank you, Madam Chair. No, because line 16 on page 2 is no longer the same line 16 on page 2 that you have in the bill. Now you have to work with the amendment G1 as amended, and if you need to put your text somewhere in there.
So basically, with the after the reference to the Canadian Charter of Rights and Freedoms, we want an addition to the reference to the Canadian Human Rights Act.
Clarify. After rights and freedoms, you want to add the Canadian Human Rights Act. Is that it? Okay. So we have a valid, I think, Mr. Miller, that's a valid sub-amendment. Yes? So we're going to discuss the sub-amendment, which is adding and the Canadian Human Rights Act after Charter of Rights and Freedoms. So, discussion, Mr. Serre.
Thanks, Madam Chair. Yes, I want. Well, first off, I know the work that Ms. Ashton has done on human rights and Indigenous, and when we look at the Canadian Human Rights Act, very important. But it's my understanding it's completely separate from this bill. So, can I ask our expert witnesses to see that this bill here, 316, is there like an overlap, or the Canadian Human Rights has its own processes? So I just want to clarify if they could add, if this is, because my understanding, I would be voting against this because it's a completely separate process outside of the scope of this bill. So I just want to get clarification, please.
Mr. McMahon, please.
Thank you, Madam Chair, for the question. We would agree this is a discussion point for sure. The Canadian Human Rights Act is governed by a separate legal regime and is administered by a commission and in some cases by a tribunal. It has a quite different scope from the existing court challenges program as well. It involves the federal machinery of government, but also the federally regulated private sector, which is not the case with the existing court challenges program, so sectors such as transport or banking. So it, on the face of it, would appear to evoke an expansion of the existing program, which we think would need to be considered carefully. Like it would raise some issues of policy alignment, we think.
Thank you, Mr. McMahon. Now, Ms. Thomas, I think your hand was up on the sub-amendment of Ms. Although I think I'm hearing that it may not be valid. It may be affecting a totally different act, but go ahead, Ms. Thomas.
Thank you. I think that was the clarification that I was looking for. In my mind, it expands the bill beyond its intended scope. So,
Ms. Ashton again, Nikki.
Okay, I appreciate the what was shared with us, I do want to make clear that we heard from a number of witnesses that expanding the scope of the bill to include a reference to the Human Rights Act was certainly in the spirit of what this bill seeks to do, and it's for that reason we put it forward, was to give marginalized communities like First Nations and others the tools to be able to fight for their rights based on the Human Rights Act, as well as the Charter of Rights and Freedoms. So it's in that spirit that we in the NDP put forward that sub-amendment, and I'm happy to vote for it.
Vote on Mr. Lawrence.
Sorry, Mr. Wall.
We're going to vote on this.
So no,
sub-amendment?
we just heard from the officials that it expands the legislation, which is, we've heard from the clerk that that's not allowed, that's out of scope. Mr. Clerk, I don't know, it appears you might have missed one here, sir.
Well, thank you, Madam Chair. Since the chair has not ruled it inadmissible, by default it would be admissible.
The mover of the bill, Mr. Surrey, intended for this bill. He said he would vote against it because it would expand the intent of his bill. And we heard from the officials that it would expand the scope of the bill. So I think I may have to move Nikki's sub-amendment inadmissible. Nikki, I'm sorry. So now let's move on to the amendment that Mr. Nur Mohammed made, because we're now going back to that. Discussion, Mr. Nur Mohammed. Anything you want to say? You spoke to it already. Unless you think you can gild the lily a bit more.
If you'd like me to gild the lily, I can, but I think in the interest of time that I'd love for us to just vote on it and get on with the game.
Is there any, now on this actual amendment, we had Mr. Saray and Ms. Thomas who wanted to speak to it. Do they still wish to speak to it? No, Mr. Saray said no. Ms. Thomas? Yes or no?
Yes. Y-E-S.
I'm sorry, Ms. Thomas, you don't have to be sarcastic. When I don't
You just have to listen.
hear you. I'm trying to listen, but my earpiece is blocked when my speaking button is on. Thank you. It's pretty simple to understand that. Now, you were saying, Ms. Thomas, you said yes?
I would like to move a sub-amendment.
Go ahead.
So I would be inserting it after G1 in its original form, which ends with Government of Canada. I would insert and that the program be overseen by an independent organization for which the selection criteria shall be made public and the final selection decision shall be tabled in each House of Parliament. Do you need me to repeat that, Clerk?
Yes, please.
And that the program be overseen by an independent organization for which the selection criteria shall be made public and the final selection decision shall be tabled in each House of Parliament.
Cast a sub-amendment by Ms. Thomas.
Thank you. So for context, again, we heard from a number of witnesses who talked about the importance of independence, transparency, and accountability around the program and the way that decisions are made. And so this would just seek to do that. So again, regardless of the government that is in place at the time, that the program would be overseen in such a way that it would be an independent organization that is overseeing it, that the selection criteria of that independent body would be made public, so there would be transparency, and that the final selection of that independent organization, that decision would be tabled with the House of Commons, therefore allowing for accountability. So it's just allowing for a clear look into how the program is run, or at least the decision-making process of each government that is in place.
A clarification, please, Ms. Thomas. You originally said be tabled in each House of Parliament. Now you're saying the House of Commons only? Or are you suggesting both houses, the Senate and the House of Commons?
It would be tabled in each House of Parliament.
Mr. McKinnon.
Yes, thank you, Chair. I just wanted to clarify Ms. Thomas's amendment, sub-amendment. She mentioned it modified the original amendment. The original amendment is gone. It is amended. It has already been sub-amended. So I kind of wonder where it's going to fit into the amendment as already amended.
I think she suggested that in Mr. Nur Mohammed's amendment, where it says by an organization independent of the Government of Canada, she then adds it after that, and that the program for which the selection criteria shall be made, blah, blah, blah. I think that's where she wants it to be added. Thank you. Okay, I shall, Ms. Lattanzio? And again.
May.
Sorry, Ms.
Yeah,
Lattanzio
that's
has
fine.
got the floor. Ms. Lattanzio, we cannot hear you. We cannot hear you. I'm sorry. Still cannot hear you. Are you muted, unmuted?
Ms. Lattanzio, can you try unplugging and replugging the headset?
Sorry, we cannot hear you.
We'll have the same technician. We're having a technician give her a call again. It was working.
And Madam Chair, while we're waiting, can I just clarify, the bill here is Mr. Ron McKinnon's bill, not my bill. So I just want to make sure that Mr. McKinnon, no, that's okay,
I thought it was
Madam
yours
Chair.
'cause you were so invested in it originally.
He means to say it's on my fault.
Technician call her.
We're going to have a technician call you, Ms. Lattanzio.
Madam Chair. Madam Chair.
We don't have other speakers. We just have
So,
Ms.
Madam-
Lattanzio. Mr. Nur Mohammed.
Madam Chair, just for clarification, for the benefit of the committee, it's 6:10. I think 6:30 is the hard stop. I just, if I could just ask you my question, what would
Have resources until 6:50.
Okay, so I mean, I don't know if others can stay on it, but I guess the question more is, if we don't get this done, is the plan then for us to move from a scheduling standpoint to continue this at the next meeting? Okay, so then Safe Sport will get, okay.
We hope so. We've been trying to do this for a long time.
Yeah,
Thank
okay.
you.
Just wanted to make.
This is better than hockey.
Thank you. So, I'm realizing that the first part of my sub-amendment is redundant, and so I would be willing to withdraw it and offer a different sub-amendment if I have the will of the committee to do so.
Anyone disagreeing? Mr. Nur Mohammed?
Not disagreeing. Wanted to. Ms. Lattanzio had sent a message just to convey what she said, so didn't want to take away from what Ms. Thomas was saying. Just wanted to, hers was a very simple point. She just wanted the amendment sent to the P9 so people could see what it was. That's all.
Can we give it to the clerk, please? The simple amendment, so she can send it to everybody?
I believe that's the clerk's job. But
Amendment, I'm writing it down as you speak. You're changing it now? Is that what you're suggesting?
Madam Chair, it would appear that we have two options here. So I'm asking for the consent of the committee to withdraw my sub-amendment and reframe it.
Will the subcommittee, will everyone give unanimous consent to withdraw her sub-amendment and rephrase it? I see no one saying no, so go ahead.
Okay, here we go. So I would be offering the following sub-amendment. After the line, independent of the government of Canada, comma, for which the selection criteria shall be made public and the final selection decision shall be tabled in each House of Parliament.
Thank you. All right, now, so is Mr. That's great. Something? I don't have it in writing either, so I think the legislative clerk is asking for it in writing.
That's no problem. I would ask for, I'm not able to offer that right now, but if we suspend for 2 seconds, I can probably get that emailed over.
All right, we will suspend. Thank you. All right. Now, Miss, have you given the written version to the clerk, Ms. Thomas?
I'll let the clerk confirm.
Amendments
Oh,
or
no,
some?
I received it, but I only have it in English, so I haven't distributed it
So you can't distribute it?
yet. Not right away, no.
No, Miss, the clerk is going to have it translated into French. It cannot be submitted to anybody from her unless it's in both English and French. So,
Madam Chair. Je m'excuse. Could we
We're
suspend for
still
2 more minutes?
suspended.
Mr. Shampoo will hear shortly. My apologies.
we're still suspended. And what? that we cannot incorporate the language of the sub-amendment until it's got its place in the right place within the amended motion already, and that we have to get some look from the legal people that the language is appropriate to fit in there, and that's not going to be able to be done within the next 20 minutes. So and then we cannot get Ms. Latanzio on because her mics are not working. So any suggestions from the committee? Otherwise, we can just sit here. We can just sit here until 10 to 6, until 10 to 7. I don't know that we should ask the clerk in future to have beer sitting in the corner in case this happens.
Lucky for us, that thing didn't pass.
So, just so you know, we are, yes, Mr. Sorry, I couldn't hear you, my mic was on speaker.
Merci, Madame la Présidente. Je ne sais pas si vous pouvez demander.
Thank you, Madam Chair. Perhaps you could ask for unanimous consent that we ask the analysts and the legislative clerk to prepare a document regarding Catherine Tate, who did not respond to the questions asked by the committee. Could we receive unanimous consent on that?
That's not what the meeting is about today, so I don't know. That'll have to be accepted unanimously by everybody, that motion be allowed to stand. So I think because we're dealing with the Bill C-316 right now, and we're waiting for translation, legal opinion on Ms. Thomas's sub-amendment, I think we just have to sit here right now, unless I get unanimous consent, and just wait out the time. Ms. Latanzio, are you able to speak? No? Interpreters? No? Ms. Latanzio?
We can't hear her.
You can hear her?
We cannot.
We cannot. So Ms. Latanzio is out of the picture. So I am at the wishes of the committee as the chair.
Madam Chair, I just want to confirm that Mr. Gord's motion passed because there was no opposition.
Sorry, I didn't hear that first part.
I just want to confirm that the motion from Mr. Gord passed because there was no opposition. I didn't hear anything.
I don't think anybody thought that it was appropriate to move that motion, which did not have 48 hours notice. So if Mr. Blord wants to write it down and present it for the Thursday meeting, that's reasonable. He can do that, but we can't accept it now because it's not on the order paper for this meeting. It's not a business meeting either. So, yes, go ahead.
Je vous ai juste demandé si.
I was just asking if you could ask that the committee give unanimous consent. You haven't asked the committee. Can you ask the committee?
Looking at the committee that they didn't want to, people were shaking their heads. And all you need is one person to say no, and you don't have unanimous consent. I saw people shaking their heads. Mr. Nur Mohammed.
Madam Chair, on this, we haven't seen the motion. It may or may not be perfectly fine. We haven't seen it. If we can have it circulated to everybody in both official languages, we'd be in a position to be able to consider it. But given that we haven't seen it, and Ms. Latanzio, we don't even know how she will weigh in, given that we haven't managed to figure out what's going on with her technical piece. I think that's probably, we'd all, I'm sure, be very happy to look at it, consider it, given that we've got lots of time on our hands for the next 14 minutes. But I think it's hard to give UC for a motion we haven't all seen and had the chance to consider.
I take that it's not unanimous consent.
And Ms.
So, sorry, Ms. Gainey, sorry. Oh, Nikki, sorry about that.
Yes, I was going to say, we need to see a written copy of what was just proposed before even being asked for unanimous consent.
So, we have 10 more minutes on the clock. Just thought you should know that. And I gather there's not unanimous consent for adjourning because nobody's moved it. Nobody seems to agree with it.
Yeah, Madam Chair, can we just adjourn? This is not, appropriate, so.
You have a motion to adjourn.
Yes, please.
Shall we call the vote?
It's ridiculous.
Clerk? Anybody opposed to the motion to adjourn? I see no hands up at all, so the meeting is adjourned.